So I'm attorney Kathleen Kane. Jon Rodis is my husband. We kind of worked together on this. Jon applied for disability many years ago, and I helped him through the process, and he's helped many people along the way. I've also represented many people with connective tissue disorders over the years in applying for disability, most specifically when we get to the hearing phase, which we'll talk about in a little bit. The first thing is there are two types of Social Security programs, and I actually left out the slide, but the one is called Social Security Disability Insurance, okay, and that's for a person who has put into the system, okay, by working, all right, and contributing to Social Security disability. It's the same pot of money that retirement Social Security comes out of. But again, because of that, you do have to have a work history, and you do have to put into the Social Security system. There's another type of Social Security called supplemental security income, and that's for people who have not worked and put into the system, and also for children that are disabled. The definition of disability is the same, but the programs are a little different. Supplemental security income, or SSI, is income and asset based, okay, meaning that you have to have a low income and basically about $2,000 or less in assets, okay? And for a child, obviously because a child doesn't necessarily have income or assets, it would be household, okay, which is why sometimes it's difficult for children because they're including their parents' income and assets. So the first decision that you have to make is to file to begin with. And this is especially kind of important with SSDI when you have worked and you've had a career. And Jon can talk a little bit about that because he was in that position years ago.
Yeah, I filed in 2001, and that's what actually led me down the road, excuse me, to my advocacy. When you file for disability, especially if you've been working, it's really difficult to lose the ability to work because everybody wants to work. So you're dealing with the depression of losing your ability to work, depression of being sick, the depression of having to deal with this process, and that's one of the reasons I do what I do. I'm a national disability and medical advocate. But the financial is really tough because nobody wants to go from making a decent amount of money to a small amount of money. So it's something I also help as an advocate. I help talk to people who are thinking about filing for disability. I don't persuade people. I want people to be comfortable, and I want them to understand what they have to do. But I want to break down disability one more step. I see it a lot. People talk about disability like it's so difficult. It's so difficult. They go through all these parameters. What disability breaks down to is proving that you cannot work 40 hours a week on a continued basis for a year or more. And then during this presentation, we'll show you ways to prove it. And one of them is to get your doctors to understand what you live with each day and how limiting it is.
Again, one of the things that I think Jon had to consider, and everybody has to consider, is even though it's a difficult decision, if your health is deteriorating because you're working, then that's really something that you have to take into consideration. I've had people work much longer than they should have at risk to their health.
I was that way. I should have filed in 1990. I went 11 years because I was in, denial. I was angry. I worked so hard to get where I got. I was making a lot of money, had a lucrative career. The last thing I want to do is give it up. The only problem was the damage I did to myself in that time. Who knows? I definitely should have filed earlier.
So the filing process, basically, when you do make the decision, there's two ways that you can go about initiating the process. One is you can actually go online, okay, and do the application online. And if you go to ssa.gov, there'll be links to applying for disability. And I'll tell you a little bit about the information that you're going to need, because you're going to need the same information if you decide to file in person. To do that, again, go on the website. There's a national number, and you can call that, tell them that you want to apply for disability, and they'll set up an appointment at your local office, okay?
Get the name of the person so you can call them again. I'm not saying about making friends with them, but have their names so you can call them back. Should I tell them my quick story?
Yes.
Probably going to bore some people that have seen my previous webinars or talks, but when like I told you how difficult it was for me to decide to file, but when I filed, I decided I would go in to the office because, I'm a personable person. I used to manage people. I figured I'm social, I'll go in and talk to them. So considering when I told you what I gave up, going into the office, I'm sitting there and I'm all anxious. And she said to me, you can go in now. And I go in, and the first thing out of the guy's mouth was, you're disabled? And I felt my fingers clenching. I was going to punch him and knock him over the desk, but then I thought, that's not going to help me get approved. But what I did do was I took a breath, and it just came to me. And I said, sir, let me just explain just part of my disability to you. Remember the last time you had a bad cold, and you were achy all over, and you felt like crap? You didn't want to go to work or school or whatever you're doing that day, but you forced yourself in? I says, I feel like that 2 days a week. I let him absorb that. So I watch his face. Now think about the last time you had a bad flu. Okay, not only did you have pain from head to toe, and you had extreme fatigue, but getting out of bed to go just to the bathroom was a super effort. I says, I feel like that 4 to 5 days a week. And his face turned red as an apple. And he said, please sit down. And then from then on, he was very nice to me. And he thanked me at the end, which I'm glad. He thanked me because you just gave me a lesson in invisible disabilities, because that's what a lot of us face, is we have an invisible disability.
And that's important throughout the process when you're trying to explain something to someone, whether you get to go in front of a person that when you're just applying, or you're in front of a judge at a hearing, you have to be able to give concrete examples, because that's what people understand. You can't just say, I'm in pain, what kind of pain, how often is your pain?
Or I have this condition.
Yeah.
Having Ehlers-Danlos, having whatever condition, Chiari, that doesn't make you disabled. It's the limitations of what the condition does to you. And then the most important person that you need to have on your side is your doctors. Because if they don't believe you, or they don't know enough, they can hurt you as far as what information they put into the records. So that's what I do as an advocate, is I teach people what to say. And normally what I do is I tell them, like the examples I gave you with the cold and the flu, that's what I did when I got a new primary. I explained that first. And then I went into the other things. And he says, well, you in pain right now? And I said, I'm in pain of every moment of every day. So then it was like, his face dropped. And then during the process, when I started, I had no one to really help me. Other than Kathleen, but I had nobody. There was nothing out there on the internet. There was nothing through originally I just thought I had Marfan syndrome, so there's nothing through the foundation. So I decided I gotta find some way to make people understand what I'm going through. My doctors, the Social Security system. So I sat down one night and I said, do my doctors really understand my disability, my limitations? And the answer was no. So I thought, okay, well, I'm going to write something up that explains it, okay? And I wrote up a quality of life statement. And then I let my doctor, I gave them a copy, and I let them read it. And one of my cardiologists actually got emotional, and he had to sit down. My primary was like, oh my God. And because of that, not only did they become more empathetic, but then they got into the records.
In terms of the filing process, whether you go in line or you do it in person, the information that you need to have is all of your doctors, all of your hospitalizations, all of your medical conditions, okay, no matter how many, or maybe some are not severe, but everything has to be in there. All of your medications, okay, everything about your medical history, and you have to have your last 15 years of work history, okay, so where you worked, approximate dates, doesn't have to be, to the day specific. And what you did on that job. That's important, because they're going to need to analyze whether or not you're able to do the jobs that you did before. So you need to specifically know or tell them what your duties are. So we kind of came up with this checklist in terms of when you initially
I actually came up with most of it. She's just not along for the ride.
Right. So you can talk about.
Okay. Why don't you tell me what they say? First one.
So you're going to have to fill out forms all along this process, believe me. But initially, you're going to fill out forms that ask, again, about the information I just went over, but also about your daily activities, what you can and can't do. So Jon can speak to that.
So with that, the forms themselves, I don't want to dump on Social Security, but a lot of the forms are very old. So I've had many people I'm helping contact me and say, this is a stupid form. I go, well, it's stupid, but answer the question and then write in with the question, as long as it has to do with the question, your answer, something regarding your limitation to that question. What is it that you're affected by? Give an example.
Talk
Yes.
about how you don't want to put.
I'm very tired, so yes, what should I tell
So
them?
basically, when you're filling out this form, this is not the time to be Superman,
Right.
right? You want to be forthright about what your limitations are,
Right.
very much so. John had the example of one of our clients who said about going to take the kids to school every day.
Oh, yeah. Yeah, he actually came to me after he lost at a hearing. And I asked him about the hearing because I need to know what was said, what was done. I need to know what the lawyer did, what the lawyer said, how prepared the lawyer was. So I asked him some questions, and he answered them. And he told me that, he says, oh, I go and I drive my kids to school. He's a single parent. I drive my kids to school. I get them up, feed them, drive my kids to school, then I go home. And I'm out for the rest of the day until I have to go pick them up. I'm laying on my back. I said, did you tell that to the judge? And he goes, no. I'm like, those are things you should tell the judge, because they need to hear what your limitations are. There's another area. There's a list called the compassion allowance list, and there's also you want to talk about that? Or unfortunately, there aren't many conditions that are actually in regards to the summit that are. I don't think any of them are on the compassion allowance list. Is a list that Social Security has that is more of a fast track to getting approved. So you might say, well, why aren't we on there? We need to work together to get it on to this compassion allowance list. The organizations themselves have to deal with Social Security to go to meetings and get them listed. So that will be a fast track. The other thing is there's a book, a listing of impairments. That's Social Security's, their little green book, their little Bible. But that list is all the systems, all the conditions, and we connective tissue disorder people, most of us don't fit the listings, meaning that we don't meet the severity. I know it sounds funny, but we don't meet the severity. I didn't meet the severity for the individual listings because the severity listings are so bad. It's like you're almost dying. Okay, there was actually when I thought I had just Marfan's, I read the listing, and the listing basically said Marfan's was listed, but basically said if a medication or a surgery doesn't repair your situation, then you're disabled. No, you're dead. So it's like that didn't make any sense. So we actually helped work with the foundation to get that change and an addendum added.
So as John indicated before, your doctor's support is really key in this process. I suggest to people before they even apply that they have a conversation with their doctor in terms of this is what I plan on doing and are you going to be supportive? Because unless you have the support of your doctor, this is going to be an impossible process, okay? So it talks here about doctor support letters and doctor's evaluations. A lot of people will say to me, well, my doctor says that he isn't able to say whether or not I'm disabled. And my answer to that is, that's correct. All right, the Social Security law indicates that a doctor is not the one to determine whether you're not disabled. That's left up to the Social Security Administration, okay? What your doctor can do is identify what your limitations are, okay? Obviously what your diagnosis is, but what your limitations are, okay? So I don't need, as an attorney, I don't ask my clients to have their doctors fill out or do a letter saying, oh, my client is disabled. What I ask them to do is fill out a form indicating what their limitations are, okay? So how far can you stand? Can you walk? Can you sit? Most importantly, with our conditions in our community, how does pain affect you? How does fatigue affect you? Are you able to consistently work an 8-hour day, a 40-hour week? Because if you're not, then you're considered disabled.
And there's also a form called the residual functional capacity form, and that it has different names in different states, but that's a form where the doctor can fill out regarding the limitations, basically.
I have their condition research. I suggest with a rare disorder that you submit some sort of medical articles concerning what your diagnosis is, and obviously, you can get them on the internet. That's something that's easy because, if you have a rare disorder, chances are the person that is evaluating your claim has no idea what it is, okay? So I usually always submit articles about, for instance, what Ehlers-Danlos is, but not only that, but how pain affects it, how fatigue affects it, and there are very significant medical
And
articles.
as
that you
far
can
as
find out there.
Ehlers-Danlos, as far as subluxations and dislocations, that's absolutely something that needs to be emphasized to the doctors, especially not only what it is, but how difficult it is to have it. I see so many times cases where people come to me where they've lost a hearing and they come to me to help them in the second case, and nothing was mentioned about the subluxation. Those alone could be disabling. So it's really important to get that message across. The other thing, is just because my brain fog is rising, is going away, is the doctors themselves. If I have, let's say one of you has a doctor that's not supportive, or maybe they just don't know much, well, there's a lot of ways to change that. If they're not supportive, then get somebody else, because you don't want someone to hurt you in the process. And as far as the children go, children applying or people that haven't worked, it's important to be able to especially have that, because you want to show the medical necessity of having to be on an insurance. Because with these conditions, you need surgeries, you need medications, you need proper care. How are you supposed to do that without having this insurance?
You can talk briefly about the Daily Journal.
Oh, the Daily Journal. My wife said to me when I was filing to keep what I thought she said like a diary. I'm like, I'm not going to keep a diary. And then she explained, well, you need to keep like a log. And what she meant is to list out daily what you're dealing with. So I wrote things like, I was walking down the hall and I walked into the wall, and it's not because I'm clumsy, it's because the whole, equilibrium. Or I haven't showered in at least 4 days, because not because I don't want to shower, it's because I don't have the energy to do it, as a lot of you know that. That's another thing to explain to your doctors, is what those limitations you have are. If they don't understand what you're living with, then they're not going to be able to help you. But my doctors, when I explain to them about the showers, I says, to you, a shower is invigorating. To me, a shower is like being tortured.
So we talked about the listing of impairments. So the process basically is when you apply, there's an initial evaluation, and there's a book, Listing of Impairments, which John mentioned earlier. And if you fit into that listing of impairments, the definition of the listing of impairments, then you're automatically approved. Ehlers-Danlos and all of the conditions that we're here about this weekend are not in the listing of impairments, okay? And again, the listing can be very, very specific anyway, so we're not going to be approved in the listing of impairment phase. A lot of people can still be approved initially in that first phase, but truthfully it's a little unlikely, and we'll talk about the phases in a second. If you're not in the listing of impairments, then the regulations call for the evaluator to look at what we call your residual functional capacity. So taking into consideration all of your conditions, all of your ailments, what are your limitations, and are those limitations allowing you to perform some type of job in the national or local economy? Okay, and that's probably where most people are going to fit, because again, we don't fit into the listing of impairments.
And that's where your doctors, and especially when you hire a lawyer, which do we talk about when? Because people ask me all the time, do I hire a lawyer up front? I say no. Because unless you can't do the paperwork yourself, because let's say you have issues with memory issues, or you don't have a family member or someone to help you, then that's when you hire a lawyer. But normally you should hire a lawyer at the reconsideration stage. That's when you need to go in front of a judge. Because Kathleen tells people when they call her, you don't need me now. You need someone like my husband as an advocate. And what I do is when I go over and review a case with someone, I go through very detailed questioning information. I build up, and I actually read a "What Makes You Disabled" statement. That's what I forgot about that. I wrote that for myself, and that's actually what I gave to the doctors, and that kind of threw them, because I talked about all the limitations, about standing, sitting, walking, fatigue, pain, dizziness, nausea, all the whole works. And when you add up all that together, if anyone looks at that and goes, "Oh no, they can still work at Walmart," they're nuts,
So these are the stages of appeal. So you apply initially, usually it's about 3 months before you receive an answer. And again, the majority of people are denied unless you fit into that listing of impairment that we talked about previously. Then you go into the reconsideration phase.
Do you want to just say quickly? Sorry.
We only have 5 minutes.
Oh, we have 5 minutes?
Yeah.
Oh.
So reconsideration, all states do not have the reconsideration phase, but most states do. The reconsideration phase is just someone else in the Social Security looking at your case, a different person, but you still are in the Social Security Administration bureaucracy, as I like to refer to it. So many people still are not approved at the reconsideration phase. So your initial 3 to 4 months for an answer, reconsideration, probably another 3 to 4 months. And then if you're denied, which again, a lot of people are, then you appeal and ask for a hearing in front of an administrative law judge. Okay, that's the key. That's when most people are approved. It usually takes a year to get there. Okay, and again, this varies throughout the country. So you're talking, again, 3 months initial, 3 months reconsideration, then a year to a hearing.
A year or more, depending on the state and the backlog. And we have more than 5 minutes. This is what happens when you're dealing with your wife when they work together. So don't do it. We have more than 5 minutes.
Okay, so the hearing, yes.
So when you were applying, did you try to keep your job during that process, or did you have to leave your job before?
I had to leave it because the job required me. Well, what happened was I went from my job to become a consultant because I thought as a consultant I was going to be able to make my own hours and it would be less burdensome on me. Well, I was wrong. The hours went down, but the pressure was the same. So do you have to stop working? No, unless you don't have to. If you have the financial need and you need to work, what is it?
Well, here's the kicker. Okay, you can't make more than, and it varies every year. This year it's $1,200 a month. Okay, if you make more than $1,200 a month, then you are said to have substantial gainful activity,
which is a joke.
Employment.
Who can live on $1,200 a month?
Which, then you're deemed not disabled automatically.
Okay.
All right,
and that's why you need to contact your legislators, both state and federal, and let them know how absurd this is. And the other aspect I want to say real fast is that you do need to get your legislators on board. Introduce yourself to your local state rep, introduce yourself to the congressman or congresswoman of your state, tell them about your condition, and give them the specifics of what your limitations are. They can be very helpful.
So you're
$1,200 after tax or $1,200 before tax?
Before. 1,200 gross. So at the hearing, which we'll talk about in a second, which is really your time to shine, so to speak, that's when you have the best opportunity of being approved. But if you're not, then you can go to the appeals council. Okay, it's not another hearing, it's just another group in Social Security looking at your hearing record and see if the judge did anything incorrectly. Your case can be remanded to the judge to make another decision. It can be overturned. Again, like any kind of appeal in the legal system, appeals are very difficult. All right. And then if you lose at the appeals council, you can actually take it to the United States District Court. Again, highly unlikely unless you have, a very kind of technical legal position to fight. And you can take it up to the Supreme Court, but they're not going to want to hear you really. So the hearing.
Like their job is to not approve.
So
You've got to beat the system.
We're really late and we have our next presenter, so I don't mean to interrupt, but we have to really.
Okay.
yeah, so we can talk if you have any other questions. But the hearing, be prepared. You can have witnesses. It's informal, but it is an evidentiary hearing, so you have to be prepared. And this is probably the time, if you haven't already, that you need to have a lawyer, okay? Because there's going to be an opportunity for cross-examination, and it's an important step. And I think that's all we have.
So
Unless you have
any
questions.
quick questions?
We can take the questions at the
Okay.
desk, right?
Yeah.
Yeah. Any questions? Social
take the
Security's not.
question.
Huh? Sorry.
Questions at the desk.
Oh, at the desk. Okay. Sorry. See, my brain fog. All right. Thanks, everybody.
Thank you so much.